In continuing our conversations about the tort of negligence, in this lesson what we're going to do is talk about the concept of foreseeability. We'll explain what foreseeability means in a little bit more detail, given how important foreseeability is to the fundamental bedrock of the tort of negligence. And then we will explain, or at least provide some further reference in the case, from the case of Alcock. So, the last few lessons we've been examining the nature of specifically the duty of care for the law of tort, specifically applying this to the tort of negligence. And we noted that one of the issues at hand in relation to establishing a duty of care, a duty to take care, is this idea of the concept of foreseeability. So, what does foreseeability mean and why is it so important? Well, it's fundamentally the bedrock of the law of negligence within the concept of the duty of care. And it's also something which enshrines an objective test. And so, not one which is subject to a particular defendant in question. And this is good, this is useful because it allows for courts to apply the law in a more objective and predictable manner. So, the concept of foreseeability is not one which is whether or not it was relevant for you as a specific individual to have foreseen an event taking place at the time. The concept of foreseeability is a test which is done on the basis of what is known to be a reasonable person and how a reasonable person ought to have foreseen in the circumstances. So, what that reasonable person ought to have foreseen. And so this is delineated from what the defendant in the case actually did foresee, or what the defendant specifically ought to have foreseen. It is what a reasonable person ought to have foreseen in a particular case. Moreover, in addition to this, when we talk about foreseeability, we are talking about foreseeability with reference to a specific claimant. So, Lord Atkin, according to Lord Atkin, the concept of a duty of care refers to a claimant who is, quote, closely and directly affected by the conduct of the defendant. This instills the next of the ideas, which is this idea of proximity as well, which we will get to in a second. But when we get to some cases in the future, we'll see cases where there have been attempts to make claims from negligence in which there is said to exist something known as claims in the air. And when we look at the concept of psychiatric injury in future lessons' time, we will see that this is something that's quite interesting to note and something that the courts have been very, very strong to clearly delineate where a claim can be made versus where a claim might not be made, okay, owing to the events of specific circumstances. Psychiatric injury is very important in that regard because it allows for essentially stretching our understanding of the concept of negligence to the extreme because of the weakening of the links between an action and the psychiatric harm which is caused as a result. In addition to this, then, there is this concept of proximity. Proximity is the second major part of a determination when we are looking at trying to establish a duty of care, a duty to take care. It arguably refers to, quote, the closeness of the relationship between the defendant and the claimant. This is taken from Giliker from 2023. Now, the concept of proximity and the degree of proximity will, of course, differ from case to case, and they would also differ from claim to claim. And one of the most important cases in negligence is the case of Alcock and the Chief Constable of South Yorkshire from 1992. What it says here is that the impracticability or unreasonableness of entertaining claims to the ultimate limits of the consequences of human activity necessarily plays a part in the court's perception of what is sufficiently proximate. Simply put, one of the key tests for determining proximity is that of the policy considerations involved in the process of making said determination. Because one of the main considerations when it comes to policy considerations is whether or not there would be a potential floodgates of litigation owing to the result of a particular case. And where there are potentially thousands of potential claimants in a case of such huge scale and magnitude, it is important that we clearly define and clearly limit what is sufficiently proximate and what is sufficiently foreseeable, or what a reasonable person ought to foresee, such as to essentially limit the number of potential claims of litigation that can actually be brought forward. So the concepts of foreseeability and proximity fall along that similar standard. Now we're going to talk about the concept of the reasonable person in more detail when we look at breach of duty and the standard of care. So we will come back to that in more detail if you feel like we haven't covered it enough yet. But then we will also come across the case of Alcock when we talk about psychiatric harm in far more detail as well, where we talk about specifically the claims for secondary victimhood. We'll get to that in future lessons time too.